Good afternoon, sir. I'm Legion Discarting and reporting Chapter 3 Evidence and Crime Lesson 1 Evidence. Lesson 1 Evidence. Evidence in its legal definition, it's the means sanctioned by these rules or ascertaining in a judicial proceeding the truth respecting a matter of faith. Also referred to a material which tends to persuade the court of the truth or probability of some fact alleged or asserted before it. Three types of evidence. Number 1, oral testimony. Number 2, documentary. Number 3, circumstantial evidence. Physical evidence, object or autopic or real evidence. Refer to physical object used as evidence which is obtained through searches at the scene of the crime. It is now limited to that which is known through the sense of vision, but it's extended to what the sense of hearing, taste, smell, and touch is perceived it by included the following: firearms and fired ammunition, knife or bulo, blood, semen, saliva, human or animal biological samples, finger and footprints, tool marks and tire tracks and hairs, fibers, glaze, other traces. D6, itong 6 na to na nagbibigay, ito po ay ang pinakamalakas na makukuha natin na ebidensya dahil sa katulad lang ng fingerprints at mga blood, semen at saliva, malalaman na natin kung sino ang gumawa ng krimen. Category of physical evidence. Associative evidence. These are evidence which links a person to a crime: impressions, broken headlights, glass found in the crime scene, in hit and run, wearing apparel of the offender, of articles of value may be recovered at the rape scene. Number 2, tracing evidence. These are evidence that may assist the investigator in location the suspect. Trace evidence is a subtle category of physical evidence that is minute and transient but measurable. Typically, this evidence does not appear until larger items of physical evidence are subjected to closer examination in laboratory. Associative evidence. Ito po ay kanyang mga natitirang gamit katulad po ng mga kunwari sa hit and run. Kung ito po ay merong broken headlights na makikita sa crime scene, ito po ay magiging mag-lead po sa suspect. Dito na po ma-apply ang tracing evidence, matrace na po natin kung sino po yung tumakbo sa hit and run. Yun po. Aircraft or shipment manifest. Physician clinic record showing medical treatment of suspect for injuries sustained in an encounter, blood stain recovered from the area transferred by the wounded suspect, and further action and the movement are examples of tracing evidence. B. Wait lang. Biological transient evidence. Number 1, biological evidence. It refers to the evidence that are commonly recovered in crime scenes. It is an evidence that can be tested through DNA, mapping, and other profiling methods. Some biological evidence that has DNA included blood, saliva, semen, slough, skin, cells, hair, urine, and facial material. Transient evidence. It is referred to the evidence that by its very nature can be easily changed or lost. It included temperature, odor, blood in the rain, and some biological and physical phenomenon. Corpus delicti. Latin term of body crime. Legal term used to describe physical or material evidence that a crime has been committed, such as a corpse of a murder victim or the clean of a torched building. Used to refer the underlying principle that without evidence of a crime having been committed, it would be unjust to convict someone. Other specific kinds of physical evidence. Soil consisted of the four organic natural materials such as rock, minerals, and decomposing plant, and may also contain man-made materials such as bricks, concrete, glass, or paint. This common scientific technique of analyzing soil is called the density gradient tube. Paint is pigmented polymer that is applied and adheres to various surface. It is possible to examine microscopically and color and shape of paint strips or other sample, as well as to determine through the use of gas chromatography. Tool mark is any mark that is created when an instrument has contact with other surface. Shoe prints and impressions. Shoe prints are created when material from the bottom of the shoes is transferred to another surface, leaving an outline at the bottom of the shoe. Number 5. Videotape evidence is potentially extremely powerful from evidence. Number 6. Dental evidence. Two primary kinds of dental evidence are dental identification and bite marks. In both instances, the fact that an individual has been unique set of teeth in terms of form, arrangement, dental work, and bite mental makes dental evidence powerful from the crime evidence. Number 7. Computer and other electronic evidence. Computers, cellular phones, and personal digital assistant may provide a wealth of information regarding communications, schedule, and criminal behaviors, and therefore they are potentially valuable source of evidence in criminal investigations. Lahat po ng binasa ko na 1 to 7 ay ito po ay malaking tulong po para makaresolba ng isang krimen, dahil ito po lahat ay ebidensya, kailangan na ebidensya po para makasolve po tayo ng isang krimen. Testimonial evidence, also known as eyewitness testimony or communicative evidence. It refers to a person's testimony offered to prove the truth of the manner of asserted. Kinds of testimonial evidence. Ordinary witness. Any person who perceived the commission of the crime and tested before the court is considered as an ordinary witness. Expert witness. A person who testimony concerning an investigation of crime is based on the training and experience. Witness. A person who testified under oath at trial or disposition in a lawsuit, and plaintiff or defendant may be witness. Deposition. It is a testimony taken orally with the attorney asking question and the defendant answering, while a court reporter or tape recorder the testament of the Itong tatlo po ay dun sa court na po mangyayari. Kung ang ordinary witness, siya lang po yung makakita ng hindi talaga nangyari, parang naglalakad lang yung criminal tapos kita niya lang ang dumaan. Pero ang number 2 na to, ito po ang nakakita talaga ng sitwasyon na merong krimen talaga naganap. Siya po ay tinatawag na expert witness. Ang witness, sila na pong lahat, tapos disposition. Documentary evidence, sa court na po mangyayari yung tatatungin ka na ng judge kung ano ba talaga yung nakita mo sa lugar, o totoo pa ba yung sinasabi niya o baka katang-isip lamang. Documentary are but not limited to the following: birth and death certificates, necropsy report, medical examination. Lesson 2 na po tayo. Lesson 2. Legal classification of evidence. Ability to establish the fact and distribute of an evidence. Direct evidence. It is that which proves that fact and dispute without the aid of any interference or permission the evidence presented to the prices of actual point at issue. Circumstantial evidence and direct evidence. The proof of actor from which take neither singly or collectively the existence of the particular fact and dispute may be inferred thus necessary of probability of consequence. Degree of value in establishing a disputed fact of evidence. Prima facie evidence. This evidence suffices for the proof of a particular fact until contradicted by the other evidence. Number 2. Conclusive evidence. This evidence is uncontrovertible or one which the law does not allow to be contradicted. It is insurmountable evidence. Witness, a person who testified under oath on a trial or disposition in lawsuit. The plaintiff defendant. Corroborative evidence. This evidence is a different kind of act and character as the already given intends to prove this proportion. Cumulative evidence. This evidence is of the same kind of character as that already given and intends to prove the same proportion. C. Weight and acceptable of the evidence. Primary or best evidence. This evidence afford the greatest certainty of the fact in question. Secondary and substitutionary evidence. This evidence is inferior to primary evidence and admissible in only the absence of the letter. Natural of an evidence. Object evidence. This evidence is addressed to the sense of the court and is capable of being exhibited by examined or viewed in the court. This is also known as autopic evidence or real evidence. Documentary evidence. This refers to evidence supplied by written instrument or delivered from conventional samples letter which deals with represented for material substance. Testimonial evidence. This evidence is either verbal or oral. It is an evidence which consists of the conventional symbol and letters by which ideas are represented for material substance. Positive evidence. This evidence exists if the witness affirms that a fact did or not occur. It is entitled to greater weight since the witness represents his personal knowledge about the presence or absence of a fact. Negative evidence. It is exists if the witness state that he did not see or know the occurrence of the fact and there is a total disclaimer of the personal knowledge. E. Equality of evidence. Relevant evidence. Evidence is relevant if the relation of the fact in the issue is to induce belief in its existence of the non-existence. Material evidence. This evidence tends to prove the fact in issue and determined by the rules of substantive law or the rules of the court. Admissible evidence. Evidence is admissible if it is relevant to the issue and not included by the rules of the court. Credible evidence. Evidence is credible if it's not only admissible evidence but also believed in use by the court in deciding cases. Lesson 3. Collecting, marketing, tagging, and preserving evidence. Collecting physical evidence. All items found in the crime scene should be collected. Like example, number 1, blood, hair, fingernail, scraping, fiber, glass, firearm, bullet, and cartridge case, seminal stain. All these 9 example is kailangan na sila kolektahin para ito po ang magiging basihan ng iyong pag-examine or pag-collect ng mga ebidensya. Kailangan jud lahat. Galing pa lang sa buhok, kaya niyo na yan matrace kung sino na po ang suspect. Marketing of physical evidence. As the evidence is collected, it is individually marked with the initials of the investigator. The marking tools depend upon the nature of the evidence. If it is hard objects such as metals and initials are scattered of the engraved by the use of the sharp pointed steel called stylus. Marking of firearms related to the evidence. Revolver, pistol, rifle, fired empty shells and modified cartridges, bullets, slugs, balls, pellets. C. Tagging evidence. Tagging of the physical evidence is being done with the use of where the initials are investigator, date, and time of the collection, specific case, and other information are written. Preserving physical evidence. Perishable material should be preserved along the way or the preservation is in order to reach out the court in the same physical condition as as when they were collected from the crime scene. This is the work from the laboratory technician. SOCO team. It includes preservation of the tool mark, reservation for the controlled substance and medical preparation, preservation of the questionable documents, preservation of the latent fingerprints. Three types of fingerprints that can be found in a crime scene. Latent fingerprint are made of the sweat and oil on the scene surface. This type of fingerprint is invisible to the naked eye and requires additional processing in order to be seen. This processing can include basic powder techniques or use of the chemical. Patent fingerprints can be made by blood, grease, ink, or dirt. This type of fingerprint is easily visible to the human eye. Plastic fingerprint are three-dimensional impressions can be made by processing your fingers in fresh paint, wax, soap, or tar. It is easily seen by the human eye and do not require additional processing for the visible purposes. These three fingerprints ang itong Latin fingerprint, marami na tayong nakikita nito sa mga movie, like pag sa glass, lagyan lang nila ng soil or uling, tapos abo scotch tape, yun makikita na nila yung fingerprint nga makakuha mo na sa kuwari sa baso nga nalagay yung fingerprint mo. Tapos itong patent fingerprint can be made by blood, like ito kay kanang pag masamad ka, like makuha na mo yung fingerprint or kanang fingerprint masamad din mong kamot nya mapurma o fingerprint kana nya. Plastic fingerprint are this national expression can made by processing fingers and paint wax. So ang kaning plastic fingerprint kay kanang dali ra nimo makita, like kanang sa pag-touch nimo sa imong cellphone mahingana or kanang sa wax sa mabilin jud maklaro jud nimo imong kuan ba fingerprint. Kaya sa mga sabon, mga wax. Good. Lesson 4. General rules and equipment of and processing evidence. General rules and collection of provision of biological materials. Use of protective gloves. Avoid coughing or sneezing in evidence materials. Packaging of biological special precaution. Ano yung mga rules nga kanang dapat care kay kasi pag magkuha ka og kanang mga evidence like sa mga fingerprint kay bawal jud ka magamit jud ka og gloves kay bawal mo abot imong mga fingerprint diya ka basig nagibidensya lang ka pero ikaw na tumapasangin lang kinay mong fingerprint kuha na kayo siya kanang ma-confuse na ang investigation kayo lagi na diya imong fingerprint nya kanang avoid sneezing kay ma-detect man na didto. Materials for evidence packaging marking and selling accessible package containers depending on the evidence. A. Paper bags, plastic bags, box, manila envelopes, small glass, vials, metal cans, acceptable seals, tamper-proof evidence tape, reinforced packaging tape, heat seal. Information on the package should be minimally include name of the agency case number, item number, date, the investigator. Mao ni siya mga kuan kanang like kinsay magkuan sa evidence like mga investigator kaning acceptable packaging containers kay kanang asa ni isulod or asa ni i-deliver ana kay dapat safe jud ang ang pinakakuan jud ani kay kaning kuan manila envelope kay katong dako. Tapos ang number 2 acceptable seals kanang i-seal nimo ang envelope kay para dili siya like katong heat seal kay butang tong lingon niya ana para dili siya Tapos ang informational sa sulod sa package sa imong example manila envelope kay kaning pangalan sa agency number, item number, date, and investigator. Additionally, packaging of evidence should include where the item was, by whom, date, and time found, description. Kung asa ni may padala, like kailangan jud ka ng exact location para dili traditional method of receiving or recording evidence. Photographs, audio or videotape, microfilm, photostat, Xerox, voice tracing, etc. Photograph is considered to be the most practical, useful, and reliable means of preservation due to the following reasons. Number 2, sketching. If no scientific apparatus to, to preserve evidence is available, then a rough drawing of the scene of the object to the preserve is done. Observation and description is done by the putting into words the person is deemed to be perceived. Portrait parley. It is referred to the verbal accurate of the picture description of the person identified. If it's a skilled investigate illustrator is available, a picture for the person to be identified may be drawn or sketch, cartographic sketch. This tree is kanang sa kuanan ni siya dapit kanang like magkuha na kag evidence like videohan nimo ang ang suspect tapos mao na imong tapos sa sketching wala kay picture kay kailangan kanang pangutanon ka unsa iyang buhok unsa ay porma siyang naong nya sa raw gallery photographic files of wanted or missing persons comparison of cartographic. Number 4, mannequin method, preservation in witness, writing notes, developing and lifting fingerprints found on the criminal scene, gathering physical evidence, plaster card, rating of evidence, subject in witness, integrity of trace evidence, protection of trace evidence of loss or contamination is essential. One of the primary parts of the contamination is from the collector to the evidence. The collector must ensure that no contaminant trace is depositing along with the evidence in question. Principle of chain of custody. It is the most critical process of evidential documentation. It is defined as a number of the person who handled and possess of the piece of the evidence that the moment that are collected, mark and tag up to the time to the final disposition of the case. Chain of custody rule. It is the paramount of importance to any investigation of the should unbroken sequence of the events that is caused by an item of evidence from the time it is found at the crime scene to the person in the court. So that's all in the chapter 3, and thank you so much for listening, and thank you. Goodbye.